my first guest and my only guest this hour, because Mr. Ryan Perryman couldn't be here this first hour, is Attorney Adam Clemens. I just used to call you Adam.
Yes, ma'am.
Let's speak up to the mic.
Yes, ma'am. Good morning.
Good morning, good morning. And Adam is a lawyer, but let's talk a little bit about your background.
Sure. I grew up in Southfield, Michigan, of course, which is right outside of the Detroit area. Um, I've been practicing criminal law and some family law for about 2 years now. And pretty much, I'm a hometown guy.
Where'd you go to college?
I went to undergrad at Villanova University. I was fortunate enough to get a college football scholarship there.
I remember.
So those were good times, and I had good times playing for the Blue Jays and for the Jayhawks growing up as well. So I'm truly that. I'm a local guy.
My son played for the Falcons.
Yeah.
Yeah, Falcons, Jayhawks. Yeah, that rivalry there. I used to love that rivalry, though. So, Adam, what did you major in undergrad?
I actually majored in criminal justice. I knew pretty early on that I wanted to be a criminal lawyer, so I went in with that focus.
Oh, okay. So you went in with the focus. They tell me that English is very important when you're trying to be a lawyer.
I would assume so.
Yeah, you were pretty good in it.
Well, my mom's an English teacher.
I know,
So
I know. And I was your drama teacher, your acting teacher.
that's correct.
And I had to make that disclosure. And by the way, Adam, I brought this for you. Am I going to be a bad daddy? Years ago, we decided to do some monologues, and they wanted to tackle the subject of fathers. And Adam wrote such a good monologue that I've kept it all these years. He graduated in 2003, and it's about a young father questioning whether or not he would be able to take care of a baby. And one thing that got me in this was I can't even take care of myself.
I remember writing it. I remember spending time working on it. I think it's still a topic that's very prevalent in the black community today. And when I say black community, I understand that, it's not just black people that struggle with this issue, but from my perspective, that's always where my focus is.
Right, right. And the question you ask here is, will I be able to give my child all that my father has given me? And that was a good question because you did get a lot in a way when you were growing up.
Oh, absolutely. I mean, I had an exceptional father. Still have an exceptional father. I want to say I had. 'Cause of course he's still
Right.
living.
He's still here. And your mother, Betty, is a wonderful mother.
Absolutely.
So I just wanted to surprise you and give you that. And you were a great writer then, and I know you're even better now. Now let's get a little bit to the law in case my viewers might have some questions for you. So you practice what kind of law?
My focus primarily is in criminal law. I do some family law, and then I handle some civil matters too, civil litigation.
So tell us, what is family law?
Family law encompasses a wide variety of areas that are what we basically call domestic relations. So that would be issues dealing with child support, issues dealing with divorce, issues dealing with child custody.
When you say issues dealing with divorce, you represent people who are getting a divorce?
Absolutely.
Okay.
And there's, you have all types of divorces. You have divorces where both parties consent and they agree. They say, hey, listen, I don't want to be married anymore. I'm ready to move on. And then you'll have cases where, one party will want a divorce and the other party won't. You'll have issues.
What happens with that? I thought you could just go on and get a divorce anyway.
Well, I mean, you can move forward with the proceedings, but the party that doesn't want the divorce can actually do things to slow you down. I mean, they can drag out the litigation. They can refuse to settle. They can demand a trial. They can demand multiple evidence. A trial. A lot of times when parties have been married for a number of years, they acquire wealth. They acquire assets. They have children. And then as a result, the litigation becomes more complicated, per se, in the event that we have to determine how that property is going to be split. Who's going to have visitation for the child, who's going to have primary custody. All of those things apply, and they can make the litigation more difficult. When I say litigation, I mean the contested portion of the divorce.
So they could have it drag on and drag on. But that doesn't mean they'll ever get back together. It's like punishing the other person, isn't it?
Well, I guess that's one way to look at it. But, at the same time, you want to make sure that whenever you are actually getting a divorce or going through with any legal proceeding, that things are done properly. You don't want to have to go back and file an appeal or hire another attorney to go back through the process again. You need to take your time and make sure it's done correctly the first time.
Wow. Well, what is your preference?
I actually prefer criminal law, but I'm happy to represent my client in whatever facet that I have the ability to do so. But
Now, you're with a law firm, right?
that's correct. I'm with the Perkins Law Group downtown. We're on Griswold and Congress in the Ford Building.
Okay, so tell me about your first criminal case. Were you nervous? What was it? I mean, you don't have to, I don't want names.
Sure. The first criminal case that I handled alone?
Yes.
The first criminal case that I handled alone was actually a drunk driving. And I do a lot of those. And, the drunk driving initially is what's called a misdemeanor offense if it's your first or second offense, and as long as no one was killed or injured severely. It would just be simply that, a drunk driving.
So they get a drunk driver, they blow so much on the Richter scale, or whatever, and so they have to go to court.
Correct.
Do all drunk drivers have to go to court?
Well, essentially, yes. It is a criminal offense. It is a misdemeanor offense, and you're going to have to appear before the judge to basically answer for the charge that's been presented to you.
So how did that go?
In that particular case, we ultimately ended up taking a guilty plea after some motions that were filed on my behalf and some strategic implementation on my part to ensure that my client's rights were fully represented. Because regardless of what crime you're accused of, you're always going to have rights that are afforded to you by way of the Constitution. And as attorneys, it's our job to make sure that our client's rights are always protected.
If you have any questions about the law, you could call us at 313-868-0342, 868-0351. Now, Adam, do you have to go up to the prison a lot?
Yes, I make local jail visits. I go to state and federal prisons as well, to wherever my clients are, wherever there's a need for advocacy or representation. That's where I'll go.
Prisons out of the city?
Absolutely. I've been to prisons in Indianapolis. I've been to prisons in the Houston area. I've been, all throughout the country doing visits to visit clients, to make sure that their rights are protected. Absolutely.
Now, there was a situation. What have you felt about these situations that have been happening with these cop killings? I mean, everyone is different, I know. But let's go back to the fake cop who killed Trayvon Martin.
Right.
And maybe you can explain something to me. They decided that, well, I think the jury was coerced to find that not guilty plea. To find him not guilty, I think. But when you try to file an appeal, or what is it that the parents can do? What do people do who are on the other end? Do they file a civil suit or what?
If you're asking me, what could the parents of Trayvon Martin do at this point?
Afterwards,
I would definitely consider filing a wrongful death action against George Zimmerman and his family, but particularly George Zimmerman. At this point, there's very little appellate rights that they would have from a family perspective. Once the trial is complete, it's just that it's a final judgment. Unless there's a reversible error, it's highly unlikely that once a final judgment is rendered, especially a judgment of not guilty, that an appeal would reverse any type of decision that was made by the jury.
What did you feel about that case? Did you get a chance to watch any of it?
I paid particularly close attention to the case. Well, not just evaluating the case as an attorney, although of course I am a defense attorney. I evaluated the case heavily as a human being, and I was mortified. I'm mortified for the family, the fact that you have a young teenager with a bright future ahead. He's got his whole life ahead of him. And the thing about it is he was innocent. And when I say innocent, he was conducting himself the way any other person would. And he responded in a state of fear. He made an effort or an attempt to run away. And the fact that he was shot down so callously, so coldly, is devastating to me as a human being. But I would say that evaluating the case, as a professional, as a defense attorney, I would say that the attorneys that represented George Zimmerman They did a phenomenal job in presenting
They
their
were better than the prosecution, I thought.
their performance. Definitely, from my perspective, was outstanding.
And you used the word performance.
Absolutely, because from our standpoint, you take a look back at that case particularly. There was a reenactment that was put on by George Zimmerman's defense attorneys, and essentially it was almost like a show, a presentation of their version of the facts from what actually took place. And apparently it had a telling effect on the jury. They actually bought in. They actually, from my perspective, believed the presentation that was provided to them, or the alternative theory, I should say, that was provided to them by the defense.
Right. You know, it's funny. I think the media plays a part in a lot of things, a lot of court cases. I really do. And not only court cases, let's look at all the things that have gone on. The other day, Mr. Scott was killed by the police officer. He had his back turned running. I guess people think nobody's watching. People are always looking at you. Have you ever found yourself having to gather witnesses?
Oh, all the time. One of the things about my approach to the law when I'm defending a case is to always be hands-on. Prior to becoming an attorney, I actually worked as an investigator for the Department of Justice, specifically the Public Defender Service in Washington, D.C.
Oh.
So I spent time in Northeast D.C., Northwest, Southeast D.C. Basically, what I would say, walking the pavement, beating the pavement, talking to residents, talking to witnesses, taking crime scene photos. And you develop a rapport, you develop an understanding of what allegedly did or didn't happen, because you're able to actually put yourself in the atmosphere where the alleged crime took place. And from that standpoint, I think you get a better understanding of what your client was experiencing on that particular day. You get a better understanding of who they are as an individual, and then you can use those experiences to convey that to a trier of fact.
But what about the stories? Because do you find differing stories, people who are around the same, looking at the same thing, sometimes see something different?
Absolutely. One of the things that I think that you'll notice when you read statements from a witness or you read statements from multiple victims is that quite often everyone sees what took place. Everyone recalls the issue differently. And a lot of times when you read the witness statements, they're not always written by the actual witnesses. They're written in a question and answer format by an investigator or an attorney. So the questions that are asked by the writer or by the investigator or by the individual who takes a statement almost can dictate the manner in which the story is presented.
Yeah, I think so, because they're leading questions sometimes too,
Sure.
aren't they?
Absolutely.
Wherein they almost put the answer within the question, the answer they want within the question.
Correct.
That's a skilled person who does that. And sometimes I think that people, the manner. For example, if you're arrested for something and do they still do the good cop, bad cop thing?
I've seen it. I've seen it in interrogation videos, absolutely. And I don't think that will ever be something that'll get too cliche or go away.
And the good cop is to make a person comfortable.
Right.
And do you find your clients sometimes talk when they shouldn't talk?
One of the things that I always try to do immediately when a client of mine is arrested is I try to get to the jail immediately, because I want to ensure that they don't make a statement. From a defense attorney's perspective, and anyone who's watching the show, I would always urge anyone who's been arrested or initially presented, stopped by law enforcement, and ultimately placed in the handcuffs and arrested, I would urge you to exercise your right to remain silent. And the reason for that is, regardless of what the individual thinks that they know about the law, that detective or that investigator, as you said with those leading questions, is very skilled. They've got years of training and experience. At that point, they're asking you questions that are going to allow them to make their conclusions about what happened. And a lot of times I find that we have clients that may think that they can outwit those detectives. And those detectives have been doing this for 15, 20 years at a time, so they know what they're doing. So the more that you talk, the more that you write down on paper, they're just going to lock you into that statement and that way of thinking, which can make defending you more difficult.
So if they do call you, they remain silent. You get down there. What do you do?
I just basically,
Do you have the police leave the room or what?
initially I asked them to
I've
leave the
been
room.
watching Law and Order a long time.
Great show, great show.
I know. Formula to the max, but I love it.
The first thing that I do is I ask for an opportunity to speak to my client, and then I ask for an opportunity to speak to them alone, and I ask that any recording devices be turned off. From my perspective, any communication that I have with my client is privileged, and what I mean by privilege is they're confidential. So that detective or that investigator is not privy to the discussions that my client and I have. At that point, I'll ask them, I'll say, hey, listen, we're going to remain silent here. We're not going to make a statement. And we'll ask to either be processed and have my client submitted for an arraignment proceeding so that they can leave after being arraigned, or they have the opportunity to release my client because they're not in fact going to go forward with an arrest.
Right, and I wanted to ask you about that, but we have a call. Miss Marcia is on the line. Good morning.
Good morning. Enjoying the show.
Thank you.
I have a friend who her court case was fought at home, was litigated at home. It was an unemployment case, and I wanted to see if this technology is going to affect the criminal cases in the future, because she had an unemployment case and she didn't have to go to court. They swore her in and the other side in via the telephone. Her lawyer was there, the judge was there, but she was sitting at home. Now, is this technology going to affect how court cases are litigated in the future?
Ma'am, thank you for your call, first of all. I would say in any time that I have an opportunity to speak to someone and there's a criminal proceeding that's pending, that's related to an unemployment action or any other action, what I would say is that an individual has to be careful that they're not making any admissions, because any testimony that the young lady would provide at an unemployment hearing, or any hearing for that matter, she's going to be held accountable for that testimony at a later period.
She says they're doing it at home, right? She said they're doing it at home. I mean, over the phone.
Right.
Can that be done? Do you think that's the way of the future?
Oh, absolutely. I've conducted several. I also do administrative hearings as well, and that's what I believe your friend experienced. That's an administrative hearing with the licensing authority who handles unemployment for the state of Michigan. So an administrative law judge actually mandates the phone call or monitors the phone call, and then from that perspective, what they do is they have all parties in a teleconference, and each side will present their case, and then ultimately that administrative law judge will issue what's called a written decision within 2 weeks of that actual hearing. So yes, that's being done, and that's currently the way the state of Michigan is handling those hearings.
Wow. How do you know? Oh, go on, Marcia.
Yeah, I was surprised that she stayed at home, because if she had known, a lot of things she wouldn't have revealed, you know.
Wow.
And she was dissatisfied.
Well, did she have a choice?
She had a state of Michigan representative, but he was at his office. She was at home, and the judge and the other side was there. They was over the phone. It was all done over telephone.
It was like a conference call. Well,
right.
Did she have a choice? Could she have gone in?
No, there was no choice given. Mm-hmm.
Wow.
That's
right.
the current.
Okay.
That's
I guess that's going to be futuristic. Okay. Thank you.
I guess it is. Thank you very much. Wow.
That's the wave of the future. I think that what you're finding is that unfortunately so many individuals are struggling with unemployment or unemployment assistance that the state is becoming overwhelmed. So in an effort to be more efficient in dealing with these hearings, rather than have someone go down to Cadillac Place where they do a lot of the hearings, they're basically conducting those over the phone now.
Wow. I tell you, you wouldn't be able to see my face, my pleading face. I'm pleading with the judge. You know, see how sad I am. See how...
Unfortunately, no.
Oh, goodness. Anyway, back to what you were talking about.
Sure.
Is there still that rule that after 24 or 48 hours, if they haven't booked them, they can let them go, or what?
Typically, the rule of thumb is that an individual can be held from anywhere from 48 to 72 hours prior to being arraigned. There's There's case law basically that suggests that states that 48 hours is a sufficient timeline to be held. So one of the things that our law firm does in the event that our client has been held for 48 hours and hasn't been arraigned, we'll ultimately get a writ of habeas corpus signed for their release. That is where a judge signs a document ordering that they be released, and that we'll bring them in for an arraignment proceeding in the event that they're going to be charged. But typically that benchmark is 48 hours that a law enforcement official can hold you, and up to 72 hours that you can be held.
And if they go over that, they've done some violation, right?
It's a constitutional violation at that point. They should be immediately released.
My goodness. So, well, tell me about this, assaults.
Okay.
If two people get into a fight,
Okay.
one hurts the other one, even though both of them are fighting, but one hurt and maybe knocks the other one out, and the other one has to go to the hospital. He's not deceased or anything. But they arrest the other person, the person who didn't get hurt.
Right.
But they were both fighting.
Correct.
Remember in high school, if two people got in a fight, both, no matter who started it, both had to be suspended?
Absolutely.
So tell me what happens there. Do they arrest both people, or they just take one to the hospital and arrest the other?
There's a number of factors that usually come into a law enforcement agent's decision in terms of who will be arrested. Typically what I see is the individual who is the initial aggressor is the individual who's charged, arrested, and proceedings are initiated against. That's typically what I see in my field. However, one of the arguments that I often present to a trier of fact, and when I say trier of fact, of course, I mean a judge or a jury, is I say, listen, these two individuals are mutual combatants, meaning that they were mutually fighting. And this essentially, from a defense perspective, at anything, my client is defending themselves, or they're both guilty of what I call disorderly conduct, but not an assaultive related offense. So that's the way I would position my case in order to defend my client who injured that individual.
Oh, I see. But then, would that even count? I mean, after you do this, what would happen? Do you think judges would take that into account, or the trier would take that into account?
I think so, and I think you have to have a good understanding for your venue. And what I mean by good understanding for your venue is you start to develop a familiarity with certain courtrooms, certain judges,
Oh, really?
arguments that they're going to receive, arguments that they're not going to receive.
So can you choose a judge?
No, unfortunately, you can't choose a judge. There are venues that are almost dictated to you, and then you have well, not almost. The venue is essentially dictated to you, but what you do have a choice of is whether to have a jury trial or a bench trial. And of course, a bench trial would be where the judge actually decides on the facts of the case.
What do you think that people prefer based on your experience?
Based upon my experience, most times people choose and prefer to be judged by a jury of their peers.
Really?
Absolutely.
What do you find with juries now? I hear people are reluctant to be on juries.
People are reluctant to be on juries for a number of reasons.
I tell you, I was directing a play at school, and I got called for jury duty. I said, no. And so I was, I'll never forget this. When they asked the questions, I was as negative. I was trying to put on my act because I had play rehearsal. And this was up in Pontiac. And then all of a sudden, the defense attorney or somebody who looked like John Lennon, he says, ladies and gentlemen, we have a jury. And I said, oh, I was in the jury. I said, oh, no, what am I going to do? I eventually had to get a note from my doctor because the play was going up next week. I couldn't leave these children hanging out there like that. But honestly, what are some of the other reasons?
People serving on a jury is essentially, it could be an interruption in your daily life. You know, we've had trials, Mr. Perkins and I have had trials that have lasted 2 weeks, 10 days at a time. So it's an interruption in your normal life. You have individuals who have children that they're taking care of. They have commitments in their own personal life. And essentially what we're asking you to do is to come in and evaluate evidence, to show up at 8 o'clock, 8:30 in the morning, and be there until 4 or 4:30 at night. And then there's the resistance of the human element. And what I mean by that is we're asking you to evaluate the evidence that we present to you. We're asking you to not do independent research. we're asking you to not go home and have discussions with your friends, family members, and loved ones about the case or the evidence that you were presented with, because they're not on the jury. You are. And we don't necessarily want their opinions to, not necessarily, we don't want their opinions to affect the outcome of our trial. And that's difficult for a lot of individuals.
I know it is difficult because you want to talk about it.
Sure.
But you can't. And I've sat on a couple of juries, and really, it is your responsibility.
Now, I think that, personally, from my perspective, and we have our flaws in the justice system. I'll be the first to admit that. But if you look around the world at different systems, I'm impressed by the fact that we have an opportunity for a citizen to be judged by a jury of their peers. And I think that that's the best system that you can have, because these individuals are going to be familiar with the community. Hopefully they'll have similar experiences to what the defendant or the litigants are experiencing on a daily basis. And those experiences are going to shape the manner in which they view the evidence.
Well, with trial by judge, does the judge, does the person testify and the witnesses testify? It's still like a regular courtroom proceeding with the jury?
Absolutely. The same proceedings as it relates to testimony, and whether or not witnesses are going to testify or have the opportunity to testify is the same. That doesn't really change per se as it relates to whether it's a jury trial or a bench trial.
Okay, let's talk about the grand jury.
Sure.
And that's important, and that's been in light of the Michael Brown case and some other cases. The grand jury. What is the grand jury?
Okay. The role of the grand jury is...
And who could be on it?
Any citizens in that particular jurisdiction can be on a grand jury. Now, with any type of jury selection, there's going to be a process by which certain individuals will be weeded out. And what I mean by weeded out is, for example, it would be highly unlikely that an attorney that I would ever have the opportunity to serve on a jury. But specifically sticking to the question, the grand jury proceedings are to determine whether or not, in fact, there's probable cause that a crime was committed. So, in terms of the standards of proof, in order to convict someone of a crime, you have proof beyond a reasonable doubt. Okay, in civil proceedings, you have what's called a preponderance of the evidence.
Okay, let's go back to reasonable doubt.
Sure.
Can some explain that?
Reasonable doubt?
Yes.
Okay, proof beyond a reasonable doubt and proof beyond a shadow of a doubt are two different things.
Wow.
Okay?
Shadow of a doubt.
Without a shadow of a doubt. And that's one of the things that I always speak about in my closing, is don't hold me to, if I'm on the defense side, I said I'm not attempting to hold the prosecutor to a standard of proof beyond a shadow of a doubt. But we are asking you to be reasonable. And one of the things that I always say to a jury in a closing argument is I ask you to ask yourself, if there's a reasonable alternative, if there's a reasonable theory, then there's not proof beyond a reasonable doubt. The prosecutor has the burden of proving that this individual committed this crime beyond a reasonable doubt, meaning that there's no reasonable alternative. There's no reasonable theory that could have been presented as to why what happened other than what the prosecution is offering. It's a high burden, and I think it should be a high burden because an individual's liberty is at stake. And what I mean by liberty, your ability to come and go freely. You could be imprisoned. You could be monitored on a probationary period. So if that liberty is going to be taken away from you, there shouldn't be a reasonable alternative for what happened. So that's the proof, the standard beyond a reasonable doubt. But that isn't the standard in a grand jury, though. I do want to be clear about that.
Okay, well, go on with the grand jury.
Sure.
So I could be on a grand jury.
Correct. And at that time, the prosecuting official...
How many are on a grand jury?
It can vary. There can be up to, I believe, 72 jurors in a federal proceeding.
72?
There could be. So the amount of... Basically, it depends on the jurisdiction. And what we had in the Michael Brown case in Missouri, that was a state grand jury. So whatever amount of jurors are sufficient in a state law proceeding for that particular jurisdiction, those will be the amount of jurors that would actually sit. And they would hear evidence only from the prosecution, none from the defense.
Oh, really?
Correct. Because at that time, the prosecution has the burden of establishing that there's probable cause that the officer, in that case was Darren Wilson, that he committed a crime. They would have to only show probable cause, which is a very, very low standard, a very low threshold.
But tell me, speaking of Darren Wilson, it took them so long. What was that about?
I believe that they were attempting to, what they say, do their due diligence in terms of gathering facts and evidence as it related to their investigation. I think that what drew the process out or caused it to be longer was that I don't think that there was a true interest in prosecuting that individual. And I think the fact that a grand jury proceeding was initiated and the manner in which it was conducted shows that.
Yeah, because I don't even think they did not arrest him initially, did they?
No, sir. No, ma'am.
It just seemed like the fix was in at the beginning.
I don't know that Darren Wilson ever was arrested at all. I think that a grand jury proceeding was initiated to determine that probable cause existed, and that once the determination that no probable cause existed, there was no reason for an arrest.
Well, it's very interesting about Ferguson because that particular day, it was August 9th, and I was at lunch with my daughter, and one of our former students who lives down there, she put on Facebook, this was before it hit the news, there's a guy laying dead in the street, and she had the picture of him right on Facebook. He's laying dead in the street. He's been laying here for a while, and nobody's doing anything about it. And I just couldn't believe it. I didn't believe it would come to that. I don't know, and now I know that some people will challenge a police officer, but then they said all the witnesses had different statements. That's what they said.
Sure, and again, it all comes down to the manner in which the questions were asked. We're not privy to the nature of the investigation. We're not privy to the nature of the questions that were asked of the witnesses. We don't know how they were framed. And the difference in the manner in which the questions are framed can cause you to get different responses. And that would be my answer to that. A lot of times we see individuals that may want to be truthful. They want to provide evidence or they want to assist in the investigation. But the manner in which the writer is asking the questions almost dictates the response in many cases.
Well, I'm going to kind of go to another topic right now that concerns the law and you and other lawyers is give me the number of things that people would need to get a lawyer for and not take on themselves. Give me an example of some areas.
I always encourage individuals to hire an attorney, not just because I'm an attorney and I want to make a lot of money and I'm looking to profit, but
well, people look at the cost, and what if they don't have a house to put up or something like that? What can they do?
Well, we do have court-appointed attorneys for criminal proceedings, and I know that a lot of times court-appointed attorneys get a bad rap for the manner in which they advocate for or represent their clients. But one thing that I do want to point out, and I find myself stating this quite often, is that when you have a court-appointed criminal attorney, they still have a duty to represent you zealously. And what I mean by zealously, they have a duty to represent you up to the standards, the ethical standards of an attorney. But they have a familiarity with that particular area of law because that's what they do on a daily basis. They're going to be in that jurisdiction quite often, and they're going to have an understanding of the intricacies actually of what goes into practicing on a daily basis in that jurisdiction.
Okay, I understood. Now I'm going to go back to what are some of the areas that people should, before they do what?
Anytime your liberty is at stake, I would say you should consider hiring an attorney if you can afford to do so. And that goes back to what I was saying before. Is there a possibility that the charge against you carries jail time, prison time? Could you potentially have your ability to come and go freely
Well, you mentioned
revoked?
child support.
Right.
Tell me about the cases. When do you find yourself in trouble? You're delinquent on child support. What's...
One of the things, as it relates to child support, one of the things that I constantly find is that individuals, their circumstances will change. And one of the things that the law, and particularly in Michigan, allows you to do is you lose your job. Okay, you've been paying child support consistently for X number of years. You lose your job. If you don't file a motion to modify your child support based upon a change in circumstances, you're going to continue to incur those costs and could ultimately get charged with a felony for not paying child support. So if you don't have the ability to hire an attorney, then you need to consult self-help. You need to go down to the friend of the court.
Self-help?
Self-help.
What's that?
You have the ability to go down to the friend of the court, and they have recipes. They have motions that are already prepared in advance. And then you can fill those out and apply the facts of your situation and submit that information to the friend of the court to get that modification of your child support. You can do that yourself.
Oh, wow. Okay.
It can be complicated, but again, it's an opportunity that individuals need to take advantage of.
So if they have a change of employment, it is incumbent upon them to go down to the friend of the court.
That's correct. Because from the state's perspective, if your individual circumstances change, we won't know. That's the duty of the parent to make sure that the state is aware of that change in circumstance. And the law actually affords that individual an opportunity to have a modification of their child support. It mandates it.
Well, if you're not working, you're getting unemployment for 90 days.
Right.
Once that unemployment runs out, what's next?
Well, there'll be an additional reduction in your child support. You're eligible for it.
What if you have to move in with your mother? I'm just trying to break it down to Chinatown. What if you have to move in with your mother and you just don't have it? You're still looking for a job, though.
The child support.
Does it still accrue?
Again, you have the ability to stop it based upon. You have to make the court aware of your circumstances. If you don't have any income, you have the onus is on the individual to make sure that the friend of the court has all the information that pertains specifically to your case, because that information, your personal information, is going to go into what's called a calculated formula, and that calculated formula takes into account for both parents' income, and that's how child support is determined.
Okay, but this person can't afford a lawyer, and you said lawyers are good for criminal cases. What happens now? Is there anybody down at friend of the court who could represent them? What's happening?
Well, no, you're not necessarily going to have an advocate for you at the friend of the court. Women and men, there are agencies all throughout the state of Michigan that are devoted towards assisting individuals who need help for domestic relations style cases. So all of those cases are basically, they have organizations that are designed to assist people that can't afford to have an attorney. And, I would encourage individuals to seek out those organizations.
Okay, because I know a lot of fathers, even the guy who got shot the other day, he didn't pay, his child support, and he was scared, and he didn't want to go to jail again.
Right.
Wow, what a way to go.
Yeah, it was pretty bad. It's pretty bad that event played a part. And I hate to say played a part because, my view on the Walter Scott murder, and I call it just that, a murder.
Let's talk. Yeah, it looked like it.
My view is that regardless of whether he ran or not, he wasn't a threat to that individual. And when I say individual, I mean the former officer. He wasn't a threat, and from my perspective, that a weapon should never have been discharged.
I agree. And it's amazing how they've had his mother. We're going to talk about this on the next show, but it's amazing how they've had his mother on talking about he's a good guy, he's a this, that, and the other thing. But when you see his actions and see the way it's like he's aiming at a man with his back turned.
I think it's obvious that the actions by the officer were callous, they were heinous, and that they were beyond reproach from my particular perspective.
Right.
I would need to see some evidence that led up to what would even remotely justify his actions, and from what I can see, there is none.
Would there be any way that this would not be a slam dunk case?
Well, one of the things that I noticed that I had an opportunity to listen to the interview from the individual who videotaped the actual shooting, and one of the things that he stated was that there was a struggle, and that there was a physical struggle between the officer and Mr. Scott at some point. And those were the words of the actual witness. So potentially what took place during that struggle could have an impact on the manner in which the evidence is presented. But I think it would be very difficult. If the officer were my client, I would be attempting to try to work out a plea deal as best I could.
Yeah. he's done. In my opinion, because I thought I saw the witness say something about he had been tased.
He had been tased, but that took place as a result of the struggle. So in an effort, from what I would say, if I was defending an officer, I would say I would attempt to plead to the trier of fact, and I'd say, hey, listen, my officer was trying to get control of this individual. He couldn't do so. He utilized his taser to try to neutralize this individual to place him in handcuffs. He was unable to do so, and then as a result, he ended up drawing his weapon. I don't think that that's a very strong argument based upon what I view on the video. You know, sometimes we're able to do a lot as defense attorneys. We're able to create alternative theories. We're able to take different scenarios and get individuals to see things a different way. But oftentimes when you have a videotape, it can be very telling and it makes it very difficult. But I would take, viewers back, and I would take listeners back to the Rodney King incident, where the beating was on tape, and it was very clear that this was an individual who was laying on the ground, who was struck multiple times, and we know what the verdict was.
Right.
So I'd never call it a slam dunk. In my opinion, that case should have been a slam dunk.
I thought so too, but apparently the looters did too.
Right, absolutely.
I mean, that was just crazy. That was really crazy. And yeah, let's talk video.
Sure.
Does the video, have you been able to, or have you had occasion to have a video yet?
Several times.
Really? So how did that work?
We've had incidents that have taken place in nightclubs and bars where we have a videotape, and we're able to we're able to frame our entire defense around what's presented in that videotape. And we're able to essentially guide viewers into what we think they see, what they should pay attention to, and what we think should be discarded for purposes of our case.
And the prosecution could do the same thing.
That's
right?
correct.
Wow. That's something, because so many people have a phone, and they say, I'm going to get this. And then you let's look at the Eric Gardner situation in New York.
Sure.
On Staten Island, I mean, the man said he can't breathe. They got him down on the ground. He can't breathe. The chokehold and all of this. And they didn't bring the cop up for trial. And that was on video.
And that was another case where the grand jury decided not to go forward with an indictment. It's sad. And from my perspective as a defense attorney, it's unacceptable. Quite often, I am presented with cases where a defendant will come to me and say, listen, I've been indicted. And we'll evaluate the evidence against my client. I'll say to myself, there's no way this amounts to probable cause. And then I'll have to bring myself back and say, hey, listen, probable cause is a very low threshold. So at the same time, if you apply that standard, you have to ask yourself, why are these prosecutors in New York and in Missouri unable to meet a low threshold to pursue charges against these officers? I don't think it's acceptable. One of the phrases that's used quite often is, you can indict a ham sandwich. I don't know if you ever heard it before.
No, I haven't heard that.
But it's funny, you can indict a ham sandwich, but we can't get an officer indicted for killing an innocent black man in New York or in Missouri. And I don't want to necessarily focus it all on race, but I think you have to consider it as a major part of what we're faced with when you evaluate the particulars of these cases.
Now, in many of the cases, do you have a lot of black clients?
Well, we've got clients of all different racial demographics.
What about, let's talk about black-on-black crime a little bit. Do you think we'll ever get away? Every time we talk about black-on-black crime, somebody says, but white people kill each other too. I guess my concern is being black and black people having, a lot of times they hang with their own or whatever. All of the killing, all the protests that go with a police officer killing a black man, which should be.
Right.
But what about, do you think there's anything we could do? In other words, have you had any habitual offenders who have constantly, all their victims have been black? And
I think that we've defended habitual criminals before, to answer your question, yes. But I think that, over the last couple of months, over the last year particularly, you've heard the phrase quite often in our community, Black Lives Matter. And I'm a huge proponent of that. But one of the things that concerns me is that black lives don't appear to matter to other
Black lives.
to black lives, right?
That's my thing. I say black lives need to matter to black lives.
Right.
And because I'm going to come in contact with you, I think about people at the gas station getting gas and they're carjacked or even hurt or worse. I mean, by somebody who doesn't know them, but they get up in the morning and say, I got to make this much money today to feed my habit, or just, I got to do this. And honestly, what can we do as a community? Is there anything we could do as a community?
Stay involved. One of the things that I try to do is I coach youth football, and I try to just reach other young black males. And I think that we have to stay involved. I mean, I know that you're always active and involved in reaching out to help mentor our youth. And I think that that's what we have to do. You asked whether or not I thought that, that would ever change, and I hope so. All I can do is remain hopeful and remain active. But what I see on a daily basis, whether it's in Oakland County, whether it's Wayne County, downtown, Frank Murphy, is that consistently there are crimes committed against our own in our community that quite often frustrate me, that make me feel as though we don't have a great understanding for the fact that, these are our black people, that we're a minority, and essentially we're contributing to our own demise. And it's frustrating to see at times, very frustrating.
It is very frustrating. Let's talk about recidivism.
Sure.
Now, they say that murder is not a recidivist crime.
Okay.
Is that true?
From our perspective, a lot of times, I would say yes. A lot of times the murder cases that we handle...
When I say recidivist, I mean they don't repeat it. That's right. What I heard, because sometimes it's done with anger or something like that.
Heat of passion crimes. These are incidences where someone's actions may have risen to a high level, to an uninspected level, and as a result, an extreme action was taken. And that's quite often the way that we present our defense to a jury or to a judge, is we'll indicate, listen, this is an individual who's prone for violence. This is not an individual who went out to hurt someone on this particular day. But the circumstances dictated actions, and as a result, an extreme action was taken. And I think that that's normally the type of cases that we see. Very rarely do I represent individuals who have schemed or plotted to kill an individual. We've had cases like that, but they're far less than the cases that are what I call crimes of passion.
Do you see, let's talk gender. Do you see more women committing crimes lately?
I've actually seen a lot of women committing crimes lately, being involved in armed robberies, being involved in conspiracies to rob. Those are some of the crimes that I've seen. Operating as what's called a mule or a transporter for drug enterprises, because it's less likely, it's thought, that women are less likely to be stopped when transporting narcotics. Because essentially when you hear about profiling cases per se, you hear about black men or minorities driving nice vehicles, getting pulled over, but very rarely do you hear about women being profiled. So the thought process is that it's less likely if a woman is carrying drugs or carrying money or for a narcotics transaction, they're less likely to be stopped by the police.
Oh, really? Now I know. So let me go. But women, and I look at it with young girls, more young girls are getting as violent as men used to be.
We've seen a rise in that trend lately, absolutely. And I think that women are violent towards each other, and a lot of times it's over men. I've represented several female clients that have gotten involved in a love triangle, and where they started acting in a moment of passion because of the fact that they're upset about someone that they're both in love with. And as a result, it's caused them to take extreme actions that are totally uncharacteristic for them. And you'd see this nice, sweet, attractive, innocent-looking girl, and then all of a sudden you read her charges, and she's charged with assault with intent to murder, or assault with intent to do great bodily harm,
and then the man's off dating someone else.
Right, and won't even show up at the trial.
That's crazy. That is really crazy. Carjackings.
Sure.
I thought they were supposed to be lower, but I hear they're still up. The rate is still up.
Unfortunately, one of the things that I'll say about carjacking is a lot of times an individual will attempt to rob someone just to take money from them or take something that they see that they have, and then during their flight of the actual incident, they will pull that person out of the vehicle and attempt to drive off. So it is a carjacking per se. It still is a carjacking, absolutely, but that wasn't their initial intent, at least as the cases that I get that I'm familiar with.
Okay. What if they just take off, make the person get over on the other side and take off with that person? Isn't that kidnapping?
It's a number of things. I can think from that scenario, it's conceivable. One of the things that we always talk about in the defense community is what's called charge stacking. So from that quick set of facts that you just provided, if that individual would have a firearm per se to order you over, you're looking at an assaultive related case. You're looking at a felony
That's
firearm
two
case.
2 years automatically with a firearm.
Felony firearm, yes.
Felony firearm.
And then if that individual has been convicted of a felony previously, you also have now a felony in possession charge. So you're now looking at felony in possession, felony firearm, carjacking, assault with a dangerous weapon. So you're now looking at all these charges from this small inference of facts. You're looking at 4, 5, and even 6 felonies.
Now, do they top the sentences for those if they're found guilty? If they say 9 years on this, 12 years on this, do they have those concurrently?
Well, it depends on the judge. The judge oftentimes has the ability to either sentence an individual or a defendant to a concurrent or a consecutive sentence. In the event that a sentence runs consecutively, it would mean that you would do 2 years on one charge, and then you would go from that point to serve the second portion of your sentence. It would be consecutive, meaning that they wouldn't all run at the same time.
Now, I'm going to ask you about this because we just have a couple of minutes. What about after a person gets out of jail, or a person who is, let's start with the person who is jailed and they're found not guilty and they've lost their job? What can they do? What can that person do?
When they come home?
Yes.
I
mean, and they're found in, I'm talking about a person who hasn't had to go to jail, but they've been arrested and maybe they have to stay in jail 90 days because they can't make the bail.
Couldn't make the bail, right. Absolutely. It's just difficult to get back on your feet, and I wish I had a better answer, but I really don't.
Are there any programs?
I know that we always try to usher individuals towards job training in the event that they don't have the ability. Let's say you were working a job that was pretty much an unskilled laborer position. We try to direct them towards getting a certification or specific training to assist them in getting another job. But dealing with that ambit of facts or that particular type of scenario, it's very difficult for them to get back on their feet oftentimes.
Now, coming out of prison, are there any programs that people could get involved in to?
We oftentimes send our clients, our minority clients especially, to Black Family Development, and we ask them to contact Black Family Development to, just to explain their scenario to them so that they can get plugged or ushered in the direction of Job Corps or ushered in the direction of job training to assist them from that perspective.
Wow.
The reentry programs unfortunately are very limited, and I don't think that the Department of Corrections really offers sufficient programs to allow someone to, reacclimate themselves to society. It makes it very difficult.
Wow. Well, Adam, you have given me an education. Oh, by the way, before we go, what about young people? Do lawyers go around to the schools and talk about these things? I think a lot of times people create crimes, but they don't realize the consequences.
Sure. One of the things that I always do is I always go back to my alma mater, which is Southfield High School. I try to make myself available for career day at all times. When I went to Wayne State for law school, I participated in the law and school days where we would actually go and present mock cases to the children in the Detroit public schools. We have teaching law in high school, basically, where law students from Wayne will go teach legal classes at the local schools in the city to try to make sure the kids are aware of these type of scenarios. And lastly, I would plug the Wayne County Prosecutor's Office because they do have a community prosecution program where I knew that they make efforts to reach out to the youth specifically as well.
What about the Augusta Straker Bar Association? Are they still around?
Absolutely.
And what do they do? Tell them quick.
I know that they make efforts, number one, to help to increase the minority bar passage rate so that there are more minority attorneys. They're very devoted to that program. They have a bar passage program. I know that also their community outreach and their leadership also makes it a point to ensure that they are a presence in the legal community.
Well, Adam, I am so proud of you. I am so proud of you because I could tell you, ladies and gentlemen, we used to have a good time in school. Not like good time, Uncle Charlie, but we used to have a good time. He's a very creative guy, and it's nothing better than having a lawyer who can really fight your case. And I really appreciate you, and he always was brilliant. But thank you so much.
Thank you, ma'am. My
And
pleasure.
what firm are you with again?
I'm with the Perkins Law Group.
Okay, Adam Clemens. And we'll be back in just a few minutes with Table Talk with Brenda Perryman.